Good afternoon. This is Ron Mickens, Lakeland, Florida, Polk County, Lakeland, Florida. This is dedicated to the rallying teachers up in Tallahassee yesterday on 13 January. I am making sure that I dedicate this video to the teachers that I met at the rally, to all of the teachers. I'm talking about fraud upon the court. Fraud upon the court and depriving me of due process and equal protection of the laws. Or we can say all of my constitutional and civil rights without any semblance of fundamental fairness or due process of law. So I want to get right into it. I want to hit the major points and make sure that we're together, because this is all about standing up for what is right and standing up for justice, standing up for us all. That's what it's about. So, the superintendent decided that he was going to recommend that I be terminated from my assistant principal's contract, my assistant principal job at a middle school here in Polk County. Before we had the school board meeting for this termination request, I had given the superintendent a list of 30 due process violations, which I asked him to consider. He said that he would. But however, he decided to recommend that my contract be terminated. At the hearing, at the school board meeting, my wife and I and my attorney, we all contended that I was entitled to notice, hearing, and just cause to be established before they made that decision to terminate my contract. School board attorney pretty much advised them that since I had to ask for a hearing, I could have a hearing later on down the road. So we didn't agree with that. Because our understanding of due process and notice and hearing, just cause, was required to be established before they took that action of disciplining me or terminating my contract as an assistant principal. However, to make a long story short, the school board voted 5-0 to terminate my contract that night. Okay. The administrative hearing was continued 6 times. So it took 33 months before we got the hearing results. The administrative law judge, I'm just going to give you a brief abstract of his findings or his determinations. He determined that the school board administrators, the superintendent, was not credible. They were not believable. He determined that the superintendent and his administrators had recommended my termination based on a non-existent factual allegation. Based on a non-existent factual allegation. That means that he had no probable cause. He didn't even meet the requirements to even have a hearing. The administrative law judge determined that their conduct, or misconduct, was egregious, outrageously bad. He determined that they had conducted an uninterrupted sequence of abuse against me. Also, he determined that the School Board Act and the superintendent and his administrative acts was ultra vires. That means that they didn't have jurisdiction. They didn't have authority. It was outside the scope of their authority. Okay? When you do something outside the scope of your authority, you're somewhat on your own. Okay? It's a criminal act. It's outside the law. It's an act of misconduct. So, in essence, the school board, superintendent, and its administrator should be subject to discipline. Okay, so let's just kind of keep it moving by letting you know that the EEOC did their investigation during this period, and while we was waiting on the hearing, the EEOC determined that the school board had violated my constitutional and civil rights. To give you an example, the EEOC concluded after investigating that more than a dozen, at least about 14 employees outside of my protected class was given notice, hearing, and just cause was established before they were disciplined or terminated. I use that just to show that is unequal treatment and a denial of due process. Okay? I was treated different. I was treated disparate. And I say that because if I was afforded these due process safeguards, they could have never terminated my contract. Okay? My understanding, my attorney understanding, and I thought it was everybody, I thought it was common knowledge. Well, they may not have been familiar with the Supreme Court precedent case, but Cleveland Board of Education versus Laudermill was the Supreme Court precedent case, and they required some kind of a hearing before you take the action of termination. Arlington versus Ham with the 11th Circuit precedent case, it required notice, hearing, and just cause be established before, because it prevents mistaken, unjustified, or wrongful termination. The Florida statute, chapter 231.36, unequivocally required notice, hearing, and just cause. That was the due process safeguards that was provided to the other employees that had been disciplined in the county. I was not given those safeguards. Equal protection safeguards, due process safeguards. Department of Labor and Employment Security determined that the school board terminated me based on alleged misconduct, and the information that the school board provided them did not support a charge of misconduct. Okay? Alleged, that's what I want you to focus on. Alleged mean what? Unproven. Okay? This is a denial of due process. You had the ethic codes required notice, hearing, and just cause before. You had school board policies and procedure required the same thing. Matter of fact, they required you to provide you with steps, what they call progressive disciplinary steps. Section 3.005, Roman number 2, A. It was imperative. That's the way they said it. It was mandated that progressive discipline steps be followed before you could even recommend disciplinary action from the superintendent. None of these procedures was followed. The main thing, too, the administrative law judge made these findings, and these findings was adopted by the school board. So the school board agreed that their conduct was egregious. They agreed that their conduct was ultra vires. They agreed that they had conducted an uninterrupted sequence of abuse against me. They agreed that they were not credible, were not believable. Okay? So let me make sure that we understand this next step. Because they adopted these findings. They had a choice. They didn't have to adopt these findings. If they disagreed with these findings, they had a period of 30 days to appeal. To appeal to the 10th Judicial Circuit of the 2nd District Court of Appeal. And object and oppose these findings. But no, I have a copy of their final order, which I'm just going to hold it up. Their final order. They adopted the administrative law judge recommended order in its entirety. 264 paragraphs of findings by the administrative law judge. That's now is the school board final order. So, the bottom line, the school board has no defense. They've agreed that they've violated my constitutional rights. In essence, they've agreed that they've violated my due process, equal protection right, First Amendment right, stigmatized me, discriminated against me based on race. I was an African American. I was vice assistant principal. I was discharged, but I was treated differently, disparate from other similar situated employees outside of my protected class. That's a racial discrimination case. Oh, they retaliated against me. Every time that I tried to assert a right, made a comment just about anything, or there was retaliation, asking them to just afford me simple fundamental rights. They just retaliated against me. Okay? So I have to go to federal court. Now, stay with me because we're talking about fraud upon the court. Okay? There's this too after our complaint had been filed for about a year, or I could clearly see the law motion in the walls. That's what they call it. Or when they just putting on this front and show that they providing you with fundamental fairness, just giving the impression that they provide you with fundamental fairness. Or we get to this point where the district court judge requests or asks the magistrate judge to do this report and recommendation. Okay, this is this too, and I'm just being frank. This is this tool that they use to deprive you of your constitutional and civil rights. Okay, the magistrate judge granted the school board summary judgment on all of my due process claims, my stigmatization claims, my race claims, my ADA claims, just about my entire complaint. Or he said that the administrative law judge findings / school board findings was overwhelmingly in my favor. I had been afforded due process. I guess in essence what he was saying, that it may have came a little late and may have came after my termination, that I was eventually afforded due process. Oh, but no, due process is before. I have substantive due process right. You got to give me notice. You got to have a charge. This is a malicious prosecution hearing. Oh, it's an administrative law judge hearing, all right. But it turned out into be a malicious prosecution hearing because they didn't even provide the administrative law judge with probable cause. They terminated me based on a non-existent factual allegation. That's not any probable cause. And the notice and hearing would have been before. I could have never been terminated from my employment. During a conference hearing while we was waiting on the administrative hearing, administrative law judge told me, he said, Mr. Mickens, I don't care what the school board did or said that night. You are not terminated. They can only terminate you if you've been afforded notice, hearing, and just cause. Now, I had a little difference with that because I wasn't working. I wasn't getting paid. Okay, the EEOC had determined that they had wrongly terminated me. But I agreed. Yeah, it was wrong for termination. It was improper. Okay? But we get to federal court and here it is, fraud on the court. Now we got to turn the innocent into being the guilty. And the guilty and being considered as the winners. Okay? Now, in other words, what I mean by that, he's granting the school board a summary judgment in favor of the school board, saying that the school board afforded me due process and equal protection. I'm just sticking with due process and equal protection because they are the central claims in the complaint. Okay? Now, I could have never been terminated if I was afforded due process. You see the lie? You see the misrepresentation? You see how they extricating the school board members and the superintendent and his administrators from their misconduct in order to deprive me of the damages that I'm entitled to? They're circumventing. They're misrepresenting. That's fraud upon the court. I think it's plain for everyone to see that I was never afforded due process. They never even reinstated me, too. That's just the retaliation, the continuous retaliation. Never even gave me a job back. Administrative law judge and the EEOC recommended that they should reinstate me back as a principal. I was just on the verge of making principal. There was 3 principals position that was coming open that summer, and certainly I was in the principal pool. In my opinion, I was leading the pack to become appointed, selected as being a principal that coming Sunday. But no, all of that was cut short by this conspiracy. This conspiracy to deprive me of everything. Okay? Let me make sure, too, that if I can make this even a little bit more clear about my federal complaint. I'm not, well, I wasn't bamboozled. I wasn't led astray. I wasn't as ignorant as they thought I might have been, I guess. Because I would need you to understand this. I have this administrative law judge / school board order. I want you to understand this because most us normal non-lawyer folks may not get this. But I did, and I do now, and I want you to get it. My federal, in reality, and I'm just making it short and trying to make it simple. There's no difference between the school board final order and my complaint. In reality, they're the same. All of my claims are supported by the school board findings. It's indisputable. They had no defense. My claims, my cause of action is made up based on their findings. They've already made these determinations. Okay? I give the administrative law judge all the credit in the world. He knew all my constitutional rights that had been violated. He wrote it up in an administrative fashion. We just had to put it in the constitutional fashion. But they're the same. School board adopted it. You see the fraud on the court? Trying to dupe me with this law in motion walls. I know my lawyer. I had learned by that time that they require my lawyer to throw me under the bus. I saw what was going on. A jury awards me. Let me give you an example. A jury awards me. They allow me to go to court with this disability / psychological testing claim. The administrative law judge and school board had already determined that they like authority, and they required me to go without a factual basis. No authority and no factual invasion. That's a substantial invasion of my privacy. The jury ruled in my favor. Granted me $300,000. The federal judge reversed it. Reversed the jury verdict. It's unbelievable. How are you going to reverse what the school board had already determined? That they like authority and that they had no factual basis. Now, I don't have to go on and on with this. My complaint is based on 4 different investigations: EEOC, Education Practice Commission, Administrative Law Judge, Department of Labor, and Employment Security. Ladies and gentlemen, you got to see my point, because there's more. And I want you to make sure that you tune in for video 6, because I want to tell you what the superintendent said about me on the stand. And I want you to imagine the superintendent saying that about you. Now, I'm not going to keep you, but you got to watch this video, and you got to stay tuned, because there's some other things that I need to go with it. Let's stand up. Let's bring about some change. Okay? I enjoyed meeting a lot of the teachers the other day, and I'll see you when I see you. So that's it for now. Bye-bye.